at the base of the microphone.
You want me to go first? You're going to go. I'm going to go first. Okay.
We are changing our orders
We're gonna
slightly,
switch.
so.
Okay, well, whatever's convenient for you.
Thank you.
So my name is Bobby Jemriska, and I'm testifying as both a victim of a juvenile that's serving life without parole, and I also do serve on the advocacy board that's listed in the agenda. I'd like to start by thanking the committee for quickly acting upon the decision and scheduling these hearings. I think a couple others mentioned it. I'm also grateful that I'm able to speak on behalf of my family, as well as those families who find this too painful to endure. I'm here today as a victim, just a victim. I remember how odd that moniker felt the first time I was referenced that way. I thought my sister was the victim, that her baby was the victim. They were the ones who were murdered. However, I am a victim of the crime committed by my sister's killer, and time has shown me why that title applies. I serve on an advocacy board for a national organization of people who are just victims. We've prayed for the past 5 or 6 years that this day would never come. I'm just a victim who has testified before this committee twice prior to today. I'm just a victim who had all sense of closure and finality in my sister's brutal murder stripped away by 5 individuals in Washington, D.C., in spite of my best efforts to make them see what that decision would mean to me. I'm just a victim who stood outside of the Supreme Court during the oral arguments because law students and people who support the murderers took up all those seats inside. I'm just a victim whose whole life is in complete upheaval because of all these things. On Tuesday of this week, while I was on a call from my job, I got a voicemail from a reporter in Pittsburgh, where I live. The message was to convey that my sister's killer had filed for an appeal and would I like to comment. I'm just a victim who found out in her voicemail that the person who brutally murdered her sister and unborn child was seeking to be freed. As I see it, there are 3 topics of concern which should be addressed in these hearings. The first is whether these existing sentences are eligible for review. The second is, if they are, how can this best be accomplished? And finally, how should the law be revised to accommodate the ruling? In terms of retroactive action, I'm not a law scholar. I know enough to get by. Us victims have to learn those lessons the hard way. However, in regard to the retroactive application of the Supreme Court ruling, I question why that is the appropriate course of action. The sentences in these cases like my sister's murder, were prosecuted and sentenced under laws that were acceptable at the time. In 1997, the Crimes Against the Unborn Child Act was passed by the Pennsylvania legislature. As I understand it, this means that my sister's murderer committed 2 murders, not 1. However, there's no do-over of his sentence or another trial as a result of that new law. The law when he murdered his baby was that the baby didn't count. And so that is what we had to live with. I would present the possibility that that is comparable to now asking for a do-over for his sentence. In both cases, the law changed, and it should apply to all cases going forward, not retroactively. But what if it is retroactive? So if it turns out that the law is retroactive, which I fully anticipate based on how victims' rights have been completely ignored on this topic to date, then I beg this committee to find a way to incorporate the victims. The notification on my voicemail regarding the appeal just further fuels my fear that victims all over this state will be completely blindsided or completely unaware of what is happening here. I believe you can make a difference and elevate the perception that we are just the victims and help our voices to be heard. The lack of consideration for the victims of these crimes in the media, the government, and by those justices in many ways makes us feel like our dead loved ones mean nothing. How best to make this a reality? Well, that will be a complex endeavor that will require efforts and resources that probably don't exist today. There's no mechanism in place to manage this situation. The victims in these cases have moved on, expecting the closure the justice system promised them to stand. For every one of me who was notified by some reporter, there are probably several more families who have no idea that these killers could go free. In many cases, they probably are not signed up for updates, since we thought life without parole meant just that. Some other things to consider from a notification perspective. A notification system needs to be developed. These murder victims have families. Those families often participated in court proceedings and gave impact statements. Every single one of these families must be made aware of this ruling and the consequences. I'm sure victims such as me would be willing to help determine how to do this. Participation. The victims of these crimes must be included in any development of a process to hear the cases and evaluate them for an opportunity to be resentenced. The glut of appeals filed via the appeal office should be held immediately with no action until a statewide process for hearing these judges and appeals is enacted. Anything short of that would be a travesty of justice for both the general public and the victims. In terms of respect, is it imperative that victims' rights be recognized in this process? The concept of victim impact statements and notifications must be part of any appeal process. Furthermore, the process of reevaluation must be a one-time proceeding without subjecting the victims to further traumatization for years to come. I urge this committee and the state Supreme Court to put the brakes on any appeal proceeding until the above conditions can be explored. To act without any of the above would be cruel and unusual punishment for the victims, an irony that is not lost on me at this point in time. In terms of the future law, the question remains what to do with juvenile life without parole in the future. It is critical that you maintain the ability to assign juvenile life without parole in cases that warrant that sentence. Again, I'm no law expert, but for the most part, I think the law works as designed today. The mandated sentences for the first and second degree murder for juvenile offenders should be replaced by a hearing to determine if that sentence is appropriate based on those crimes. This will ensure that the sentences are still available for murderers who kill in cold blood that deserve that sentence. This hearing could be a secondary step in the process of moving the case to adult court or a separate hearing closer to the trial. In either scenario, a simple examination of the case will help frame the appropriateness of the sentence. For example, if you stab and beat your girlfriend to death with a knife you brought from home and leave her and your unborn child to bleed to death in a schoolyard. I thank you again for your swift action on this topic. I urge you to be the voice of reason in a world where we are just the victims. With careful consideration of the issue and how every action impacts people who have suffered more than you can ever comprehend, you can be the light in our very bleak perception of our place in the justice system.
Thank you very much for being here today. I know it's very difficult for you to be here, and we have in the legislature tried to bring the victims into a place of empowerment so they can be part of and notified of every process, and we passed laws that do that. They're not perfect, and I'm sure they have to be reinforced, but we're very concerned about that issue and to make sure that you're part of this process. Thanks. So that's why we wanted you to be here, and thank you for being here.
Thank you.
Yes.
Yes. Morning, Senator. I also